Georgia is really lucky, and so is Tennessee, and we're about to hear how lucky we are to have great United States attorneys in key positions. All of our guests coming up are all formerly career assistant U.S. attorneys with lots of credibility, and our prosecutions in Georgia and Tennessee are in good hands at the Department of Justice. I'm really delighted to introduce someone I consider to be a true patriot and the person who's committed to justice. Paul Murphy is a partner at King & Spalding, and he is in their special matters and government investigation practice. I think I've known Paul ever since he started practicing law, because I've been around a little bit longer. But I think, Paul, you've been at it now for 30 years, hard to believe. And maybe that's not long enough, or too short.
It seems longer.
Okay, all right. And so life in dog years is something that Paul has experienced, because he most recently served as the FBI Chief of Staff to Director Chris Wray. And again, that was, I would see Paul in the airport in Washington when he was transiting back and forth to have visitation rights with his wife and family. And I just think it's an incredible amount of commitment you've had to the Department of Justice. Also, you served as U.S. Attorney in the Southern District of Georgia. So it's a great pleasure to introduce Paul Murphy, who's going to moderate our next panel. Paul.
Well, thanks, Jim. It's great to be here, and I really appreciate the invitation, you and Brian having me here again for this program. We really do have a great panel, and I want to take a moment and introduce them. But Joe's right, we're fortunate in all 4 of these districts that we have U.S. attorneys who served previously as career prosecutors. They have a ton of experience, and so I think, we'll have a good discussion today. To my immediate left is Ryan Buchanan. Ryan, as you know, is the U.S. Attorney here in the Northern District of Georgia. He was confirmed in April of last year. Ryan serves on the AGAC, the Attorney General's Advisory Committee. He's Vice Chair of the Terrorism and National Security Subcommittee. He's been with the Department of Justice for a number of years, since 2010. He started out as an AUSA in the Northern District of Alabama, and then he came over to the Northern District of Georgia and was in that position before being elevated to his current position. Before that, he was in private practice with McGuire Woods. Next to Ryan, we've got Peter Leary, the U.S. Attorney for the Middle District of Georgia. He was confirmed by the Senate last December, but he served in that position before that, first in an acting capacity and then in an interim capacity, starting, I think, back in December of 2020. Before that, he was an assistant U.S. attorney in the Middle District of Georgia. He started in that position back in 2012. And before then, he was with federal programs, joining the Department of Justice through the honors program in D.C. We have also with us today the United States Attorney for the Middle District of Tennessee, Henry Leventis. He was confirmed to his position in December of 2022. Before that, he was a partner with Spencer Fain in Nashville. And Henry also has had a very long tenure with DOJ. He spent 10 years as a career prosecutor, first as a trial attorney with the criminal section of the Civil Rights Division, and later as an assistant U.S. attorney in the Middle District of Tennessee, where Henry focused, as you might expect, on civil rights, but also white-collar criminal prosecutions. And then finally, we have Jill Steinberg, the U.S. Attorney in the Southern District of Georgia. She's been in that position following her confirmation since February of this year. Before that, she was at Ballard Spar in private practice. But Jill had, before going into private practice, a 13-year career with the department. She was an assistant U.S. attorney in the Northern District of Georgia. where she ultimately became the deputy criminal chief. Later, she was an associate deputy AG in Washington, where she oversaw some of the enforcement programs for the department, sexual exploitation, for example, and human trafficking. And then earlier in her career, Jill was actually an assistant district attorney with the Philadelphia DA's office. So a lot of experience up here, and it's great to be with you guys. Looking forward to a good discussion, and we're just going to jump right into it. And here is what I want to ask the group, and this is something that each of you should probably talk about. So the Biden administration very early talked about the fact that white-collar crime, particularly corporate crime, would be an area of focus for DOJ. And I'm curious whether you think that's been the case, whether white-collar crime is a focus for your district, and if it is, where does it stand relative to your other enforcement priorities? And I ask that question because there's a lot coming at you when you're the U.S. attorney. You've got drug cases, gun cases, violent crime. All of those are really important. And so I'm curious what your thoughts are about that, and if you could talk a little bit about what you're doing in your district and how important this is. And Brian, why don't we start with you?
Sure. First, I'd like to thank Joe and Brian for this opportunity. I believe that this institute is in many respects like homecoming for us to be with some folks who had long tenures with the department, but who have moved on to private practice. It's just good to be around everyone again. And also good to share the stage with some of my friends and my colleagues. You're right, Paul, that the administration has made white-collar crime and corporate crime a focus, and it certainly has been coming out of COVID and sort of working through some more of those individual type white-collar cases. We have attempted to move it more into the corporate space. I believe we're doing so, but we are doing so with the idea of viewing our districts as a whole, and understanding that all of the enforcement priorities work together. And we certainly understand that if we have a violent crime problem, we can run away our corporate folks, which may ultimately sort of limit our efforts at corporate enforcement when there's less corporate activity going on in the districts. And so viewing our districts holistically has been a goal, but making certain that as we move through all of the COVID and PPP and the individual corporate enforcement, individual white-collar enforcement aspects, that we broaden our spectrum a little bit to make certain that our corporate participants, corporate citizens are responsible, and that they follow the law, and that we engage with them just as we would individuals.
Peter, do you want to talk about the Middle District a bit?
Sure, and again, thank you for inviting me to be here. Serendipitously, this is actually my 1,000th day sitting in the job as United States Attorney in some capacity in the Middle District of Georgia, so I'm delighted to spend it with you all. So for the Middle District of Georgia, we certainly are prosecuting a wide variety of white-collar fraud matters, certainly not in the same volume as some of the larger districts, which will come as no surprise to folks in this audience. And most of our work is focused more on an individual basis. We do some corporate work. Yeah, I'm not sure I'm broadcasting here. Oh, there I am. We do some corporate work. We've had some environmental and cyber cases recently, and I know we'll talk about some of that later. But simply put, our primary focus right now is on violent crime. We have had a real struggle, an ongoing struggle in Middle Georgia with violent crime. And again, to Ryan's point, if we can't manage that and provide the safety, then there's a significant trickle-down effect with the community, with the corporations, with building the area that we want to have to bring in those folks. But we're we're certainly seeing a wide variety of white collar and fraud, and that's in line with what the administration wants us focusing on.
Henry, what about the Middle District of Tennessee? Tell us a little about white collar crime in your district, whether that's a focus area, and if it is, where does that stand relative to your other obligations?
Thank you, and thanks Joe and Brian for having me here today. It's been nice to be with you during the conference. White collar crime is a very big priority for us in Nashville and in Middle Tennessee. Those of you who are familiar with my district, those of you who are from my district, appreciate that it's grown at a rapid pace over the last decade. We're also the healthcare capital of the country, especially with respect to provider-based healthcare, and we're the state capital. And so, in my mind, and you mentioned, when you were talking about my background, I was the white collar chief. In my mind, white collar is incredibly important for the Justice Department to focus on, because if we don't do it, it doesn't get done. There are not state or local agencies that can effectively police white collar crime, and so it's incumbent upon us to do that ourselves. And then with respect to the white collar crime we're looking at, healthcare fraud is a huge priority for us, both with respect to our civil enforcement and our criminal enforcement, because as I mentioned, there's a large healthcare presence in our district. And then public corruption is right up there towards the top of our priority list in the white collar space as well.
Jill, what about the Southern District of Georgia? And I like to say that the Southern District of Georgia is the true Southern District for all of those SD and Y folks. So yeah, why don't you talk about that?
Amen. Thank you for having me. This is the first time I've been to this conference, so thank you for having me. I appreciate it. Being on this side of it, the lights are very bright. But I see some of my people there in the back. I can't believe they're backbenching me. My Northern District former colleagues. The portfolio of the white collar work in the Southern District, I think is reflective of the district. It's dominated more by small and medium-sized businesses. There are some large businesses, but it's not like maybe some larger urban environments, and I think the work is reflective of that. I think it's also reflective of, sort of what's dominant in the district in other ways. We have a lot of military facilities there, as you know, so there might be, say, foreign procurement fraud that we see. We have a lot of major hospitals, medical systems, and we see a lot of healthcare fraud as well. And so I think the portfolio is reflective of the district, which it should be. I think, ultimately, we're here to serve our communities. And so the work will be driven by the needs of the district. And that's same with the public safety aspect of it. Some of our communities, although small, are seeing an outsized amount of violence. And so the battle is always trying to sort of straddle those, all the different priorities, as you articulated, that we're sort of accountable for. I will say, in the Southern District, like in the Middle District of Georgia, we're a smaller community, the office is smaller, the agency resources are less. And so part of the role I think leadership has is to bring all of the constituents together and figure out how is it that we drive more work in this area. You can't just do it with AUSAs, you also need agency bodies. And so having conversations with the ASACs or the SACs and saying, hey, I know that everyone in the FBI has to run out and find a missing child. Every single person in the office is going to go out and do the search warrant. But I need long-term focus on this project, or otherwise these cases are not going to get off the ground, because the cadence and the level of specialty that you have to build these cases is very different than doing an OCDF case or doing an adopted 922 case. And so that's sort of been my approach, is to look at every single component of what makes, a proper white collar, enforcement space in the district, and patching it all together and seeing how we can take the small number of resources we have and point them in that direction in a coordinated way. And some of it is internalizing the work and hiring contractors or FTEs to do the investigatory work within the U.S. Attorney's Office, because the agency resources are becoming less and less. And so that's been the focus in the few months that I've been there.
I want to come back to the issue of resources, but first let's talk a bit about some of these substantive areas. A couple of you mentioned PPP fraud, and I'm curious to what extent your white collar docket is filled with COVID fraud cases, because I think a lot of people in the defense bar thought that the U.S. Attorney's offices would have their hands full with COVID fraud and that it might impact investigations and prosecutions in other white-collar areas. And I'm just curious, to what extent is that the case?
In the Northern District, we, like Clemson was before they played Duke, we were a top 10 ranked district in terms of PPP cases. And it really did sort of dominate our docket for a while. We handled that by spreading it out across the criminal division. But we've slowly, the cadence on that is slowed a bit and allowed us to think more about those bigger corporate type cases. And I think that may be the case, I'll speak for my friends, but it may be the case sort of across the country, that we hope that that work is like, we don't have the luxury of ignoring the corporate cases, we don't have the luxury of ignoring the fentanyl scourge, and so we have to do all of the things at once. And so we're trying our best to make certain that we have individual responsibility in the corporate context, and then corporate responsibility as well.
And I'll just add, I think it's come as a surprise to us just how the PPP fraud infiltrated other areas of criminal law, that we're busting the PPP fraud ring that's being run out of a state prison. We're seeing violent crime that's directly related to PPP fraud. We're seeing, again, the gangs that are realizing, why are we doing the drug dealing as much? That might be more dangerous and there's a lower profit margin than getting into the government fraud. And so in any one of our cases, there's almost, if we wanted, the ability to throw a PPP fraud claim on top of the gun charge, the drug charge, the gang charge. So that's something that, again, it's not just our folks who focus more on white collar that are prosecuting those cases. Those are becoming add-on charges across the board in a lot of our other crimes.
Henry, Jill?
We're certainly seeing a lot of PPP fraud. We're analyzing it the way we analyze, with respect to intake, we're analyzing it the way we analyze a lot of our economic crimes, which is to say, we're looking at the dollar amounts in question. We're looking whether there are aggravating factors that warrant a federal prosecution. For example, if it's a government employee who submitted a fraudulent application. But we're not overwhelmed. We haven't been overwhelmed in our district with PPP fraud.
Jill?
There's a lot of it. It's about 50% of, if you can sort of carve out the white collar portfolio, because we don't have sections, but it's about half of the work that they're doing. A lot of it is sort of the PPP style case, but they're starting to see other types of frauds that I think sort of fall within the COVID umbrella, that are sort of species of maybe what a traditional healthcare fraud case would look like providers billing for services that were provided, but they were something that falls under the COVID umbrella, or there's something that there's an employee relief tax credit that I guess entities and individuals were applying for, and maybe they were doing so inappropriately. So we're starting to see sort of branches off of the sort of COVID tree that are being explored. And so I think the COVID train is still running, but it might be that we see different varieties of cases. And at least in our district, I see it as being a significant part of the work, for at least another year or two. And some districts, including the Southern District of Georgia, have received specific FTEs, which basically are employees, to do that work. And if we have that FTE, we have to use it for that work. And so, I foresee that as still being a lot of what comes out of the district.
Henry, you mentioned that healthcare fraud is a focus in the Middle District of Tennessee. That's obviously been a big initiative for DOJ for a really long time, probably 25, 30 years now. I know you have a lot of healthcare providers, companies located in the Middle District of Tennessee. What kinds of healthcare fraud cases are you seeing? Is your office focused on? Because we all know there are all kinds of healthcare fraud investigations, anti-kickback statute stuff, billing for services not rendered, coding-related issues. What are you focused on? What are you seeing?
So we're seeing a lot of the same schemes that we've seen historically with a telemedicine aspect to it. We just finished the healthcare fraud trial last week where there was a kickback arrangement between a doctor in Illinois and a telemedicine company, and the doctor was essentially signing off on genetic testing for Medicare patients he'd never met, and seemingly thinking he could do it because he was doing it through telemedicine. So we're seeing telemedicine work its way into all manner of healthcare fraud schemes, whether it's upcoding or medically unnecessary billing. That's certainly been a thing. We're seeing a decline in the number of overprescribing cases that we've seen historically. There's still some out there, certainly, but unfortunately, the drug epidemic has seemed to progress towards fentanyl and away from overprescribing physicians. We're seeing some hospice fraud, certifications for people to stay in hospice who are not terminally ill. But those are, it's the same stuff we've seen historically, just kind of different iterations of it over time. And then obviously those services and items that Medicare will reimburse a high rate for are always kind of front and center in these schemes because that's where the money is.
What are others saying in the healthcare fraud area? I suspect that this is an area of focus really for all of the districts, just given the fact that there's specific funding for healthcare fraud positions.
In the Northern District, it's been strikingly similar to what Henry's experiencing in the District of Tennessee.
Yeah.
Yeah, same for us, and again, I would certainly echo that the old pill mill model is one we're just not seeing as much because unfortunately fentanyl has just taken over that arena and obviously in a really, really terrible space, and so we're seeing a lot of fentanyl in pretty much every drug case we have, and just a tremendous amount of overdose deaths in that arena.
What about environmental criminal investigations? President Biden talked a lot about environmental enforcement even before he took office, while he was on the campaign trail. And then after he took office, he talked about the importance of environmental enforcement, both on the criminal side, also on the civil side. There's been a lot of talk about environmental justice. I'm curious to what extent this is a focus for your offices, what you're seeing. On my side of the table, on the defense side, I do think there's been an uptick in environmental criminal enforcement. But can you talk a bit about that?
Yes, and so you're right that there was talk of environmental justice. We have long had, I think, certainly in my district and many others, an environmental justice point of contact. We were instructed a little bit ago to have an environmental justice coordinator. Point of contact coordinator is a very discreet government distinction that makes a whole lot of sense to us. So we had this coordinator. Our coordinator in the Northern District is a civil AUSA. And we're starting to see nationally some of these investigations come to fruition. I know there was a settlement in the Southern District of Mississippi related to water, one also in the Southern District of Texas, Houston as well. So we're starting to see some of these, particularly on the civil side. I think a lot of offices sort of place this coordinator spot in their civil divisions. We're starting to see them sort of pop up all across the country.
We've had a handful of Clean Water Act cases recently, and to Jill's point earlier, we have the same challenge, of course, with the EPA, with the number of agents being spread thin. But one of the advantages that we have is based in Atlanta. There's a regional counsel's office that has a number of attorneys who will partner with us on those cases, similar to what we might see with partnering with Maine Justice on a fraud case, but they're more local here in the state, and they've got that subject matter expertise. So in a couple of those cases, we partner our AUSAs with those EPA regional councils, and they've been able to, again, help us walk through some very subject matter specific criminal statutes in charging those cases. So that's been an added resource that we've been taking advantage of.
Jill, are you saying environmental enforcement matters?
I agree with you and with Brian that there's been an uptick nationally, but I've not, district specific, we've not seen anything outside the norm of what we've seen historically.
There are two elements in the Southern District. One relates to the port, which is a little bit different than what the group has been discussing, but the port of Savannah is the third largest by volume in the country, which is quite outsized compared to the size of the law enforcement sort of community in the district, and the U.S. Attorney's Office, our competition being LA and New York. And the port of Savannah is projected to be the second by volume quite soon. And so some of the environmental work is seen coming out of the port, individuals, bringing in items, like CI cases that, shouldn't be brought into the port. So there have been a number of cases in and around that. But also one of the first meetings I had was with EPA, CID, when I came to the office, and they articulated some pretty specific things that they were interested in. One relates to sort of $20 billion in grants that are rolling out of Washington relating to clean energy projects, particularly for underserved communities. And so they're very interested in how these funds will be utilized. And so I expect there might be casework that comes out of that. And there's other pieces of legislation that are similarly incentivizing companies to decrease sort of their greenhouse footprint. And representations that are made regarding those commitments might be subject to certain fraud statutes. And I know they're very focused on that. And historically, the office has had a good relationship with them, so I wouldn't be surprised to see some of those cases.
What about public corruption investigations? I know the Northern District of Georgia has a long track record in the public integrity area, but other districts do too. Jill in the Southern District of Georgia has done a lot of work over the years in the public integrity space. Tell me if that's still an area of focus, what you're doing in that area.
It is, and I think you sort of see the ebb and flow, and I think some of it depends on priorities of the individual office leadership and also DC leadership. That's something that's very near and dear to my heart as a part of the Northern District of Georgia Public Corruption Crew. And so that's been a very high priority for me along with the port. And part of it sort of goes back to what I said at the beginning about making sure that you're aligning your resources. It's not enough just to have AUSAs who are interested and trained up, and that is something that we're working on. We're hiring in effect sort of 20% of our workforce in the next 2 or 3 months. And so just filling open positions so people can have the time to work those cases, which are complex and have a different I always call it cadence, because that's the best way to describe it in a violent crime case. It's really important to get those people in place and trained up, but also having the agencies involved, whether it's, FBI, who, they're spread very thin. They're having to do every type of violation in the Southern District, or relying on GBI, putting together, different OIGs, like whoever is out there that's willing to do it, talking to each and every one of them and getting them on board. And so it's one of those things that the work you do today might not manifest for 2 or 3 years, and I won't be here to take credit for it, but I hope laying the foundation of having the people in all the places that they need to be, having them trained up to do it, and putting the resources in place within the office or within agencies, as you keep beating that drum, will mean that whether it's in 2024 or 2025, that cases that are either happening now will come to a close, whether that be the case ends with no indictment or the case is indicted, or we do more business and lead development, which I think really needs to happen. It takes a long time to build sources, particularly in a small community. And so cracking all those things is a long-term project and very much one that's frontline for me.
Ryan, what about Northern District?
So we are reaping the benefits of Jill's investigations from years ago. And she's exactly right that those cases take a long time. And my office has been really busy in that space. Like any good citizen, I hope for the near end of that season because I want us to have good, trusted government. As Peter mentioned earlier, we're seeing PPP cases sort of in that space. I think we have a couple of trials coming up related to the city of Atlanta. But it's always a priority because we understand the importance of having the citizens of our district be able to trust and rely upon their government. And we understand too, like Jill mentioned, those are extremely sort of resource-intensive investigations. You can have a team of folks who spends years on one particular case with one particular set of targets, and so finding that balance, doing multiple things at the same time, is difficult. We have sort of beefed up our public integrity and civil rights and made that one section. We've added some very, very experienced AUSAs to that section, but Jill's exactly right. We are in hiring mode right now, and being able to have enough of a full, team to make certain that we can handle the individual PPP cases, we can have folks doing long-term corporate engagement and corporate investigations, and then also being able to adapt to really sensitive public integrity matters is really a challenge. So it's always a priority, but it remains a really tough set of cases to work.
Peter?
I would just, to Henry's point earlier, it has to be a priority because we're a unique player in that space that we can bring to bear an outside perspective often, whether it's a sheriff or a politician or what have you. I would add for this audience in particular, we've had a couple of investigations, and when you're getting into folks who have a position of trust, I think we really have gone out of our way to keep them absolutely off anybody's radar because we don't want to sully the reputation of somebody who may be in a position of public trust such that even the specter of investigation can impact their future. And so we've had some very positive discussions with defense counsel who, a target becomes aware or somebody's a subject of some inquiry, and we've had some very positive discussions that have resulted in charges not being brought in part because of the interaction we had with the defense counsel to say, they say, look, we know you're looking at us, here are the things that we want to be able to provide to you so that you understand there's not been wrongdoing here. And again, that's been a productive dialogue that we've had with some folks in the white collar defense arena.
Henry, what about Nashville?
Yeah, so public corruption is always going to be a huge priority for us. Every time Attorney General Garland speaks in public, he talks about the core mission of the department being upholding the rule of law, protecting the public, and upholding civil rights. And public corruption, I think, falls squarely in that first category of upholding the rule of law. And so some of you know that before becoming special counsel, Jack Smith was the acting U.S. attorney in Nashville. And before that, he was the head of the public integrity section in D.C. He came to Nashville in, I think it was 14, and really laid a solid foundation for upping our game in the public corruption space. And we've seen the results of that, including recently, we obtained a 21-month sentence on a state senator for corruption, public finance, campaign finance charges. And then we have a trial coming up with the former Speaker of the House of Tennessee this spring. And so we've done some really interesting things lately in the public corruption space. We've got a number of investigations ongoing, and so it will always be a priority.
Peter, you mentioned cyber earlier, and I want to touch on cyber. We talked about this in our planning call. I've always questioned whether cybercrime is really white-collar crime, and the reason I question that is because a lot of the perpetrators are actually, nation states, organized crime, or a combination of the two. criminal organizations and some of our foreign adversaries. But this is a really big deal for DOJ. It's a big deal for the FBI. I'm curious the extent to which you're focused on this, you're devoting resources to it, what kinds of things you're seeing in the cybercrime area, and also your outreach, if any, to the business community, because really the business community more often than not is the victim when it comes to cybercrime. So, Peter, can you talk a bit about that?
Sure, and this is an area that's near and dear to my heart. Folks with DOJ experience will know that the offices have one or more chips, the computer hacking intellectual property attorney. Now is our office is chipped for a number of years. And you're correct that in a lot of the sort of corporate or business victimization space, we may bring a prosecution and it may not ultimately be particularly satisfying to the victim because the bad actor is overseas. We can put out a red notice, we may never get them, or again, it's somebody who's being protected by a nation state. So what we really have tried to emphasize is that educational component. We organized a couple of years ago a cybersecurity roundtable that was anyone from CEO to folks who are doing accounting work, to folks who are doing the actual on-the-ground IT work. And so the Attorney General Advisory Committee on Cyber, of which I'm a part of and others are as well, is really encouraging folks to reach out and have those discussions and bring together those players so that you can not only understand what might be a way to stop these events from victimizing businesses, but also, again, when that inevitable victimization occurs, who do you call? And making sure that they understand the FBI is really trying to step into that space and wants to be available. The Secret Service is very active in that space, and understanding from a business's perspective, how are we going to protect the company when you have shareholders who may bring lawsuits afterwards, and again, the number of aspects that go beyond prosecution, and I think where attorneys have a large role to play in that space in helping businesses get ready for what may be always being attacked and hopefully not being victimized, or if you are, how do you bounce back from that?
Yeah, I know the FBI has really tried to convey to the business community across the country that if they're the victim of a cyber attack, whether it's ransomware, a BEC scheme, to contact the Bureau, reach out as soon as possible. And I think, the FBI has made some inroads, but, my take on it is that it's still a little bit of a challenge. And I'm curious what you all think about that.
You're right. Peter and I met in that national security space years ago when I was in the USA in Birmingham. In northern Alabama, that cyber sort of space is centered on sort of national security, clear defense contractors, that type of work, which seems a little more connected to national security. But over in the Northern District of Atlanta, or Northern District of Georgia, where we have 36 Fortune 500 companies and 70 cents of every dollar cycles through our fintech community, we're just a target-rich environment. And the cyber game is a little more economic than it is national security. But as you mentioned, a lot of that is conducted by nation states. So it does blur. So Peter's cyber committee does the same thing that my national security committee does in terms of building relationships with the community. And it is strikingly similar to how we approach victims in every space. There is a level of victim shame that is the same in a gang violence case, a romance scheme case where a victim has given away a lot of money, and in the corporate context where a victim has experienced some vulnerability with respect to their data. And so having all of these community stakeholders and all of these victims understand that we're here to help and that we can provide help without deepening the injury, and that there obviously, as Peter says, in the corporate context, there can be consequences for what happens. None of that is made better by not communicating and engaging with law enforcement. So we have tried over the past several years to make certain that we approach these victims in a way that allows them some comfort in how they engage with us. We're fortunate in that a lot of our former agents now work corporate security positions, and so they're able to socialize this aspect within their own organizations long before it happens. But when it does, we encourage communication, but we want to make certain that we are proactive in building relationships ahead of time so that there's a level of trust there that when the inevitable breach or cyber attack does happen, our corporate partners understand that we can actually provide some assistance to them.
Henry, Jill, any comments on cybercrime?
We dedicate a lot of resources to cybercrime, and it's kind of what you alluded to earlier. It's something that often we don't have a lot to show for it. Right? We're investigating mostly folks who are overseas, often in countries where we can't extradite from. But nonetheless, it's incredibly important because our business community and individuals within our community feel victimized and are victimized on a regular basis and feel somewhat helpless about what can be done. The timing of this is interesting for me because during our planning call, I knew we were going to be issuing a press release yesterday about the unsealing of some indictments with respect to individuals in Eastern Europe who have been victimizing businesses and individuals in Middle Tennessee and around the world for a number of years, and we just unsealed those indictments yesterday. So there are instances where we can take action, and we do, but these are very resource-intensive investigations, and all too often there's not enough that we can do about it.
Jill?
I agree with what Ryan said about just engagement with the community, just like we would do in any other type of offense. And I find that to be even more so true in the Southern District of Georgia. You know, there are a lot of smaller communities, people know each other, there's an element of trust. And so just getting out there and talking about what we do and putting a face to it is very helpful, particularly sometimes when you're in an environment that isn't necessarily entirely friendly to the federal government. And so doing that and doing it in a way that's sincere and bringing folks with you that are part of the community helps a great deal, no matter what the violation is. And we're working on putting a roundtable together, as Peter has done. That's not something that we've done yet, but we're working on. And so I look forward to doing that because I think it will help a good bit. I find that just looking someone in the eye and establishing that relationship goes very far. We have a lot of cyber facilitated crimes. I mean, maybe less what someone would consider core cyber cases outside the national security space. We have a lot of assets in the national security space, as one might expect. But in the sort of economic space, there are a lot of cyber facilitated crimes is how I would describe it. So there have been a lot of sort of thefts of personal information that result in sort of fake real estate transactions. For some reason, the real estate community has been sort of affected in an outsized way in the district, romance scams and things like that. And a lot of that also is, outreach. Sometimes it doesn't result in the prosecution, but there are ways for us to perhaps intervene early and stop the flow of money. And so there's a lot of sort of intervention events that may not result in a case.
I just want to add one more thing. I think we often, and maybe this community thinks of this as from the large corporate standpoint for victimization, but certainly what we've also seen is educational institutions as targets, often small municipalities as targets, community banks, where again, they may not have that large resource infrastructure, and so that is something we're trying to do. Again, I was just in Albany, Georgia recently and meeting with folks in the Chamber of Commerce, and we had really large banks that are represented who've got a larger infrastructure, and then we had really small community banks where, again, they may be more attractive targets in a lot of ways. So we're also certainly trying to reach out to those educational institutions, to the hospitals. So it's not just the largest folks who are targets.
Jill, you talked earlier about resources, really, I think mostly on the agent side, but I am curious the extent to which you have resources in your office to work white collar crime, AUSAs, in-house investigators, and then I'm also curious in your districts what your agent resources are. And one thing I know from my time at the Bureau is the FBI has a lot on its plate, right? It's not just all white-collar crime. A big, component of what the FBI does is national security, and then, there's violent crime, all kinds of things the Bureau is responsible for. So, talk to us a little bit about resources that you have, in-house with your law enforcement partners.
Certainly. So with respect to what's inside the U.S. Attorney's Office, the office does not have sections, unlike larger offices, but there is benefit to having a group of people with expertise who are communicating, doing training, working with a certain set of agents over and over again. You develop sort of muscle memory and a level of efficiency and expertise. And so, although there's not necessarily interest in creating sections in our district, I've created basically a working group so we can sort of start to model some of that without having formal sections. And so I think between the hiring and forming this sort of working group, we can kind of create something, get some of the benefits of sectioning in a larger office without forcing people into this. And so that's one of the things that I'm doing to hope to kind of like get some of the aspects of the specialization that a larger office has. And similarly, finding investigatory assets housed in the office that we control. And so we have 2 full-time individuals who are in effect agents inside the U.S. Attorney's Office. We have 2 contractors, and we're going to bring another one on board because of what it is that you talked about, not just with FBI but other agencies have a number of different priorities. The Secret Service has a fraud portfolio, but particularly now in the next year they're going to be drawn away. You never know when they're going to be there. And IRS is the same way. They can be really helpful, but they have other things on their plate, and they're also very slimly resourced. We have a lot of OIGs, but it's very small, and a lot of them are housed in the Northern District of Georgia in Atlanta, and when they're not physically there, sometimes they can forget about us. And so, you have that aspect of competing with the larger, jurisdiction, but we have a lot of different OIGs, so we patch them together. Some of them are housed in Savannah, which does help. HHS and DCIS are both actually in our building and share office space with us. And so not surprisingly, we get more out of them. And also it's just reflective of the needs of the district. And so that's sort of the resource pool. And I think the battle is how is it that you take those little bits and have them all sort of coordinated and working together, on the same mission at the same pace.
Ron?
So I know my friends will kid me about this later. We have roughly a little over 100 lawyers, 150 or so staff, and we don't have the resources that we need, not to cover our 46 counties and 7.5 million folks. Since the last institute, we have hired roughly almost 20 new AUSAs, because a lot of my colleagues are sitting in the back now. And so we're constantly trying to have enough bodies, but then, as Jill mentioned, enough in-house expertise to handle these growing matters. Additionally, as technology changes, we are trying to keep up, and we're trying to understand ways to better manage the data that we have, to conduct the appropriate analysis that we would like to do. We are collecting more and more and more in every type of case imaginable. There are folks who've done bank robbery cases in the past and would not have dreamed of having, a terabyte of information that arises out of a bank robbery conspiracy. But everyone has little tiny computers in their pockets now. And so we're collecting and having to work with the FBI to make certain that we have the infrastructure and also the expertise to understand sort of what the evidence is and how do we best digest it, how do we best get it over to the defense bar, and that is an emerging problem. We're hiring a person right now in AUSA to simply manage our e-litigation. And that is something that I believe our agency, I know the FBI struggles with it, DOJ struggles with it, our other partners struggle as well with managing large volumes of data, managing the shift to AI and what that means for our investigations and our cases, and still doing it in a way that comports obviously with the Constitution and allows us, we hope, to still move through our investigations in a quick fashion and in a way that still upholds the rule of law, as Henry says, because some of these new advances in technology sort of haven't been put through the full, test of Constitution analysis, and so that part is difficult and it's a challenge for us as well.
I mean, I think I speak for everybody when I really express sympathy for Ryan that he only has 100
Gloves are off.
assistant U.S. attorneys to work on 49 counties, you said?
46.
46. We in the Middle District of Georgia have the luxury of approximately 35 AUSAs to handle our 70 counties. But we can all agree the Northern District needs more resources. I would just say it is always a challenge. We're also doing the same large hiring efforts that I think all of our districts are going through. One change that we're working to institute is we've had contractors who've worked in-house in the healthcare and ACE arena who've done great work, but we've repackaged 2 of our FTEs to hopefully have a full-time ACE investigator in-house and also a full-time civil rights investigator in-house. And again, that's 2 areas that we really want to see a point of emphasis, and having contractors work in our office is great, but there's often not the same continuity. We lost a great contractor who went to HHS because that person wanted a full-time federal job, and we've not had the ability to offer that internally in the past. And so that's something that we're working to staff up. Again, to Jill's point, as we try to muster all the various resources from various agencies that are actually in our district, and then work to get the attention of those resources that are in Atlanta but covering Middle Georgia, and the remainder of which are in Savannah and covering Middle Georgia. So again, we're trying to plus up from within in addition to inspire folks.
Henry, what about your district?
Yeah, so I too would like to express my sympathy for Ryan.
I will cover.
We have, with respect to white collar crime, we have about 7 federal prosecutors focused in that area, and that covers cyber, it covers healthcare, it covers public corruption, it covers financial crimes. And then we have another 5 or so ACE attorneys in our civil division. And I will say that, most of our corporate enforcement in the Middle District of Tennessee is done through our ACE unit and through our False Claims Act work. But occasionally it's also done with our criminal division and our white collar unit. And we are hoping to get some contractor investigators, because that can be an incredibly important resource. I say this all the time, the weak link in the investigative chain and the prosecutorial chain with respect to white collar in Tennessee is the number of federal agents focused in that space. When we find out about problematic activity out in the world, we can put together teams to effectively investigate healthcare fraud, for example. We've got a great Tennessee Bureau of Investigation. It's been great. They have a great MFUCU, Medicaid Fraud Control Unit, that partners with the FBI, that partners with HHS OIG. We often enlist TRICARE OIG. So we can do that. We can come up with creative ways to compile a sufficient investigative team. What we don't have are people who are coming to work every day, enough people who are coming to work every day trying to proactively find the white-collar crime out in the community. And so that's a challenge. You know, Dag Monaco came to our district recently, and I spent the day advocating for more resources.
And she said they're all going to North Georgia.
And explaining why Atlanta doesn't need it. On the encouraging note is that the FBI has historically been 2 offices in Memphis, one in Memphis and one in Knoxville, and a resident agency in Nashville. They're now consolidating and expect within the next calendar year or so that they will be consolidated in Nashville. We have reason to believe that will mean more white-collar investigators for our district, which is important because, again, Nashville is not the city it was even 10 years ago. It looks more like Atlanta than it does like Chattanooga. And so we really need to be prepared to respond to the needs of Nashville as it exists today. We're also, so because we don't have the investigative resources that we would like to have and I think are warranted by the district, we do rely heavily on data analysis, especially in the healthcare space, and we work with our partners at Maine Justice who have a lot of tools in that space to figure out, billing trends that suggest problematic activity by a provider, for example, and kind of, in doing so, efficiently focus our resources on places we expect to find criminal activity.
Yeah, you're doing data mining, basically,
Yeah, sure.
right?
Absolutely.
Yeah. Are there other ways that your offices develop leads in white-collar cases? I'm curious about that. I mean, data mining is one, but are you relying on CIs? Do you read the newspapers? Do you get leads from, state and local law enforcement partners? How do you generate white-collar investigations?
I think you just named many of them.
Okay.
And I would add to that, whistleblowers are an incredibly important source of white-collar investigations and our False Claims Act work. And then we're excited about the voluntary self-disclosure policy because essentially what it's doing is enlisting the business community to be partners in this space and incentivizing them to come forward when they find problematic activity within the organization. So that's another way that we hope will identify white-collar crime.
Well, I want to talk to you about the VSD policy, but maybe before we do that, we spend a moment talking about the Monaco memo that came out a year ago in September of last year, because there's a lot in that memo. Voluntary disclosures is certainly a part of it, but there's also, a section in there on corporate cooperation. And, really, I think in this administration, we've reverted back to the Yates memo, at least in my judgment, where, if a company wants to get cooperation credit, it basically needs to, disclose all relevant facts regarding, all individuals who participated in the problematic conduct. And that's sort of a threshold requirement to even qualify for cooperation credit. And I'm curious whether you agree with that and what your thoughts are about it. Does anybody want to field that?
So, just as a preliminary matter, I think that the sort of the through line in the memo, both the Monaco memo back to Yates, is trust, and it's incumbent upon the 4 of us and the others who occupy our roles across the country to build trust in our communities with our corporate citizens, just like we do our individual citizens, and just like we do particular communities all across our districts. And without that level of trust, I think that the flow of corporate cooperation, just like the flow of individual cooperation, is slow. And so I think this memo puts some responsibility, we read it as heaping responsibility on corporate entities to come to us. But I believe it's correctly, and I imagine my friend shared the sentiment, that it puts responsibility on our offices to build those relationships and to prove ourselves sort of worthy of that trust, such that corporate folks report things to us with the understanding that once we receive that information, that our response is going to be sort of in compliance with the memo, and we'll do so in a way that comports with justice, and also specifically with the individual policies.
And we've had good luck with that. I mean, there's one person in the room, I won't name, who we had an interaction with this on, and I think it was a very positive sort of outcome for that person, for their client, that because there was that sense of trust, and this is something that Dag Miller spoke about yesterday, there was an ongoing sort of evolution of information as it was coming out, and it wasn't, and this company and this client attorney came forward early and said, here's what we know, we're working on finding out this additional information, but we want to keep you in the loop early, and again, we were able to build a resolution there that I think worked well for everybody because we were able to develop that relationship as it went through.
Well, I totally agree that that's the approach as defense counsel that one needs to take with the U.S. Attorney's Office. And I also think that, given, Dag's pronouncements, whether you're talking about voluntary disclosure or cooperation credit, more often than not, as a defense lawyer, you're going to have an ongoing dialogue with the U.S. Attorney's Office, and you're going to make a series of presentations where you're sort of laying out, if you represent the company, what happened. To me, I guess the question I have is all relevant facts regarding all individuals who participated or were involved in the misconduct under investigation to even get through the gate for cooperation credit. That's a pretty high bar, and I wonder about that at times because if you're representing a company where there are a number of people who were involved or touched the conduct that's under investigation, that can be a pretty monumental undertaking as defense counsel to come up with all relevant facts regarding all of these people who may have been, implicated or involved in, the conduct that's under investigation or that you're disclosing. And there are times I wonder, is that the most efficient, economical, effective way to proceed, or should the bar be lower, where the disclosure of relevant facts should only be sort of the key players as opposed to all individuals?
What do you think?
I'm not trying to put you on the spot, but I am putting you on the spot.
The language is all relevant facts known to the company.
Yeah.
Right, and it's incumbent upon you as outside counsel, or if you're inside counsel, to do a diligent investigation.
Yeah.
And so it's not going to be a good look, I imagine, if you've done a kind of a half-baked investigation and bring that to the U.S. Attorney's Office, and subsequently we're going to do our own investigation, and we find a lot more relevant information that goes to the problematic conduct. So I'm fine with the language the way it is.
Let me ask this question. What if the company, through its counsel, has done a diligent investigation, but they're just not able to develop all relevant facts? Because, we all know, everybody in this room on both sides of the table, that sometimes it's hard to develop all relevant facts. I mean, you may have people who, refuse to talk with you, and, if you represent the company, just like you may have people who refuse to talk with you if you represent the government. How does that factor into your analysis if you're evaluating cooperation on the part of the company?
Each case is fact specific, and I think we're going to look at the presentation, and oftentimes it's an iterative thing, right? It's a conversation that's going on over the course of months, if not longer. And where there are areas where you can't provide relevant facts, then hopefully you could articulate the reason why you couldn't do it. And if you can't or you won't, then I would think that would be less beneficial for you and your client than if you can, and you will.
And it's with everything else in our business, it's trust and reputation. I mean, these are hopefully, presumably not the one time this happens. We're gonna be dealing with this attorney in the future, and if there's a level of trust that when they say it's been thorough and they've uncovered everything they can, then we're gonna think back on what happened last time we interacted with that individual.
Yeah, that makes sense to me, Peter. It sounds like basically the thought is, if you're doing a credible investigation that's thorough and you run into some roadblocks, that's not necessarily going to be held against you if you've really, made your best effort, and probably explain what you've done as part of your investigation too, right? And demonstrated what the hurdle was, what the challenges were.
If you're coming to us saying that the CFO got in the car and drove to a non-extradited country and took all his files with him, that's reasonable. I don't know what was in the CFO's files because we physically cannot, review them. If you're saying I didn't bother talking to the CFO and this is about financial crime within the organization, credibility is on a downward trajectory at this point.
That makes sense. Well, what about the timeliness of cooperation? The Monaco memo talks a lot about the timeliness of cooperation and says that prosecutors need to get information swiftly and without delay, and that, lawyers with DOJ need to evaluate whether cooperation was timely. What does that mean in your judgment? What's timely cooperation?
From my perspective, timeliness is judged the way we judge a lot of things in our space. If you think about the law, there are a lot of tests that aren't scientifically, discernible in terms of outcome. What is probable cause? What is reasonable suspicion? What is substantial assistance? And I think these are the same types of criteria that we deal with all the time. You can't make a timely disclosure of something that you don't know. And so I would benchmark it to when is it that someone in a position of authority would have reasonably known, and did they know enough about it to articulate it? I think, again, we go back to communication and credibility. If at some point it becomes too long, it becomes protracted. I don't know how many days that is, but that's the art of the law, isn't it? That's why, we've hopefully achieved the level of, being practitioners at the level that we're at. Is it clients engage us, or, the government elevates us to these positions to make these hard decisions. And so I don't know that that makes people feel better, but it makes everyone in this room very valuable to their clients to figure out when is it that you know enough and there's enough credible information to come forward and striking that balance. And I think, in a way, that is a dialogue between you and the CRIM or the attorney's office that, why is it that you made the call when you made the call? And I think if it's in good faith, you're probably not going to have too many problems.
Any other views on that?
I think some of that sort of bumps up against what's the compliance culture. Like if you've got a rigorous and working, functional compliance program, you're likely to learn about something earlier, and hopefully that will prompt you to disclose it earlier. But if you've got your head in the corporate sand, then it's less likely you'll learn of it more quickly, less likely that you will disclose it more quickly. And so it's sort of a holistic view that really sort of helps us make these sort of tough disclosures, like what is, what's relevant and what is timely. It's a holistic, and I think that the policy sort of gets at that. Like it's this holistic approach to corporate activity that really sort of drives the whole thing.
I would add, we recognize that there's tension between the desire to disclose in a timely fashion and the desire to get a handle on what's going on in an organization. And so the policy is written, talks about disclosing all facts known to the company at the moment of disclosure. Right? It's not coming to the government and giving us 90% of what you know. So, and it also, if not explicitly, tacitly recognizes that this is going to be the beginning of a conversation. Mm-hmm. I think there are markers that would identify what's not timely. What's not timely is when the conduct is on the front page of the local paper, and then you come to us a week later and tell us about what's going on in the company. Or, more likely, is when a whistleblower has come to the government and kind of explained everything going on in the organization, and then you show up 2-3 weeks later. But then there are, it's always fact specific, and there are always going to be points along the spectrum of not timely to timely.
We'll know it when we see it.
That's comforting. Henry, you talked about the voluntary disclosure policy for the U.S. Attorney's offices. Can you discuss, what that entails, what the policy is?
Sure.
Just at a high level.
Yeah, so the policy, as I mentioned, I think earlier, is designed to incentivize companies to report criminal activity they find in an organization through clear benefits with respect to how the department's going to handle a disclosure versus if we find out about it on our own. And so it talks about the disclosure must be voluntary. In other words, you can't have a pre-existing obligation to report. The disclosure must be timely, and we just discussed that. It must include remediation, so that could be clawing back executive compensation, could be putting in place, could be a number of things too, depending on the conduct that's at issue. And then it should include cooperation. And if you do that, if a company does that, in most instances, barring aggravating circumstances, there can, we won't ask for a guilty plea. There may be penalties involved, but the penalties will be below the low end of the guidelines range. And so what we've tried to do is incentivize companies to self-report. And I think it's a great idea. As you know, every litigating component within the department has a voluntary self-disclosure policy in place now.
And we talked a bit about this before today's program. I'm curious why there are so many voluntary disclosure policies throughout the department. I mean, if the goal is to provide some transparency and some certainty to companies that want to make a self-disclosure, why are there so many different VSD policies as opposed to one overarching policy for the department? Because there are some differences between the policies. Any thoughts on that?
I think it goes, in some respects, I talk about district all the time in terms of, what happens in Atlanta and Fulton and DeKalb and Gwinnett and Cobb is way different than what happens up here in Barrow Hall and the outer parts of Gwinnett. And I think that's true across the country. We have such diverse districts, and the criminal division operates all throughout those districts. But I do think that the goal, and it's something that we're striving towards and haven't fully attained, particularly given how corporations have footprints all over the place, is we don't want there to be a vast difference in what happens and what the policy is, let's say like a Walmart in Arkansas versus another company that operates in the Southern District of New York. And so that's a goal of the department. Certainly, something that is not fully achieved, given the fact that we have these various policies across the country. But we do believe that it's necessary to provide that certainty and transparency and consistency. And so I think that this memo hopefully sort of drives at that, but you're right that we're not there. We're not there yet.
Yeah, and I guess, we talked about this too, that, some of these other policies are, subject area specific, whether you're talking about national security related issues or environmental issues. And so I imagine there's some adjustments, considerations around the margins that might factor into, some of those other policies too, right?
I think that's right. I also, was looking at the language of the policy, and it does speak to, for example, if you were to voluntary self-disclosure, an environmental crime to U.S. Attorney's Office that historically, typically would be handled jointly with the ENRD. We're going to work out the appropriate VSD to employ in that instance, and it kind of speaks to that in the U.S. Attorney's Office policy. And I think the reason there might be one policy for the U.S. Attorney's Office community and one policy for NSD, for example, or ENRD, is because there's not complete overlap between what those divisions do and what the U.S. Attorney's Office does, even with the criminal division. They do a lot of what we do, but we do a lot of things they don't do. So we thought it was appropriate to have one policy for the whole U.S. Attorney community, but not necessarily one department-wide policy.
One question that I want to ask about, voluntary disclosures and cooperation, but really, cooperation, even in the absence of a voluntary disclosure, is, do you believe that an organization can, disclose all relevant facts, but still get cooperation credit if the organization, wants to talk about what those facts mean? Because, there are many cases where, the facts may not necessarily be in dispute, but the significance of the facts is subject to debate. And so, can a company make a disclosure, turn over relevant facts, and then still have a healthy dialogue with the U.S. Attorney's Office about the law and how significant are these facts?
I don't know that the attorney bringing that information in is doing their job if they don't do that. I mean, to me, that's very valuable to us as we're evaluating how the company sees what these facts mean in that context. And so I recognize that particularly in the outset, there may be something of a gulf between how the company and their counsel views the facts and the attorney's office does. But again, to that communication point, I think that's the attorney doing their job and also being able to listen and convey back to their client if we believe the facts could be viewed in a different light, that I think they at least have had the opportunity to share their view, hear our view, and then continue that dialogue.
Any other thoughts?
I agree with that. There's sort of the question of whether or not you've cooperated and what credit you're going to get for it. But once you sort of pass that threshold, it's like, what's the disposition of the case? Like you would in an individual prosecution, as the person cooperated or reached the threshold of substantial assistance, yes or no? Okay, now what does the sentence yield over the 3553A factors? And so I think they're two separate things, but we would expect that dialogue to happen, with respect to both issues. And I think particularly in this space where you have individuals who are, fairly sophisticated practitioners, folks are very eager up front to do all that advocacy, and I appreciate that. I've been in that position myself. What I will say is sometimes, we get so involved in our cases, we feel so connected as advocates, people who, come to know this entity and the individuals who represent that entity and feel so strongly about it. The only danger sometimes I see is when you don't sort of separate that out, the facts and the disclosure from the advocacy about outcome. is that sometimes it can color your presentation, and some things can get downplayed. And so that's, to me, the only danger is just trying to step back and looking at it as objectively as possible, because as the receiver of the information on the government side, sometimes I sort of see people getting, blending those a little bit too much, and instead, coming forward in a way that's objective. You do look like you're conducting an objective internal investigation. And then once you pass that threshold, you're like, all right, now let me move on to the advocacy part of this program. So that would just be my only sort of practical experience about those two goals.
So we're almost out of time. We didn't cover near what we had hoped to cover. I do want to ask, one final question. Ryan and I were talking about this, earlier this morning. There's been a lot of criticism of the Department of Justice in recent years. There's been a lot of criticism of the FBI in recent years, and federal law enforcement in general. I'm curious whether that has made your jobs more challenging. Any thoughts about that?
Sure, and I think it goes way back to something that Peter noted earlier. Our applications are down since 2018 about 40%. And the 2018 portion is significant because that's pre-pandemic. So telework was not a factor. And it's also, as we understand it, before y'all started paying associates in some type of crazy fashion, right? And so if we take telework, we take the pandemic out, we're left with an understanding that department, federal law enforcement in general, has suffered some reputational harm that has made folks less willing to come work with us, for one, but I think more importantly, has eroded the trust that we have with folks. As a line AUSA, I picked this up in terms of questions that I get back from grand jurors. We'd hear about it in jury selection. I hear about it at cocktail parties, barbecue, kid events. There's just been an erosion of trust. And so you're absolutely correct that you fast forward years later in this role, that has made our jobs more difficult. And so I know that I have and others have, we have tried to pound the pavement, to get out with our stakeholders, to go out with our law enforcement partners, because it's been my experience that as folks get to know us, and you may disagree with me now, but as folks get to know us, we generally build more trust. And building more trust, it's just better for everything. It's better for the safety of our communities. It's better for our corporate health. It's better for the public integrity of our local governments. But it's a two-way street that we certainly take responsibility for taking the lead on. But that has absolutely been an occurrence that, as a longtime prosecutor, and I know some folks in the room, friends from Birmingham who feel the same, we have noticed this sort of across the country. There are times where we used to call an FBI special agent. A lot of folks had never seen an FBI special agent, and they were inclined, just on that person's position, to trust the testimony that she gave from the witness stand. Now you see more questions about, well, what about the body cam? What about these other folks who were there? And we are leaning into that. Most local police departments utilize body cam federally. That's on the way as well. And so we understand sort of raising that level of transparency is important to building trust, but so are just the old-fashioned sort of in-person relationships. And I hope that y'all understand that as practitioners, that we seek to build those relationships with you so that we can not only steal your talented associates, but also so that we can improve corporate responsibility, individual responsibility, and ultimately public safety.
Any final comments, other comments?
I agree with everything Ryan said, and to me, at the end of the day, I don't believe whether it's the U.S. Attorney's Office or FBI or whoever, we're not entitled to anybody's trust, because we earn everybody's trust, and that's something we do every day, and if you trip and fall in that effort, it is awfully hard to regain lost ground. And so, again, I've said before, DOJ is the only place I ever wanted to work as a lawyer, which I realize I've taken a substantial step towards kicking myself out of that role at some point in the future. But again, that's because I love this department, and I'm very grateful that the folks who we work with in our office feel the same way, come to the job every day for that reason, and the same thing our law enforcement partners. And that's what our community wants, and that's what our community deserves, is we should be there for the right reasons, we should be willing to listen, and we should be aware that we're having to earn that trust every day, and that if there's been an erosion of trust, then that's on us, and we need to fight to get it back.
Well, I think we're, do you have a comment?
No, I would just echo what Ryan and Peter have said, and add, I suppose, that I feel like it's incumbent upon us to be out in the community, shining light on the work we're doing, and making it clear that we're reasonable, thoughtful individuals who are inclined to work towards justice, not winning at all costs, and in doing so, start to rebuild back a lot of the trust that's been lost.
I agree. And with respect to the individuals in this particular space, if you're having an interaction with an AUSA or, criminal risk management, and there's some discussion about, provision of the VSD policy or the nature of a cooperation credit or what the outcome is going to be, you always should work through the proper chain of command, but always know that, we're here as the leadership team to make sure that, we are within the office, engaging in sort of the even-handed disposition of matters, but also that we're in compliance with, the dictates of our leaders in DC. And you should never hesitate to, say something if you feel like things are, not being handled as they should be. I certainly expect in all of our offices they generally are, but I think sometimes people can be a little shy about that, and never hesitate to work yourself through the chain of command and pick up the phone to any one of us. And I'll speak for myself, to me, if necessary.
Well, I think we're out of time. Thanks for being here, and thank you for your service.